Well, good morning, everyone. Welcome to the first meeting of the House Privileges and Elections Subcommittee on Voting Rights. My name is Delegate Joshua Cole. I represent Virginia's 65th House District, and I am excited and elated to be here bright and early at 7 a.m. I will ask if the clerk will open the roll. The clerk may close the roll. And seeing that we have quorum, we'll get started this morning. This is a very important and key subcommittee to make sure that we're protecting, I like to say la-di-da-di, and everybody's voting rights. And so there will be some important bills that are coming before this subcommittee, so this work is very important. I like to run an efficient subcommittee. I like to get in and get out with respect to the people who are here, the citizens who have traveled from far to come and testify. And so we'll start off with a quick, brief introduction of our subcommittee members, starting with our Uber chair to my right.
Good morning, Delegate Sia Price, Chair of Privileges and Elections from the 8th District and Newport News.
Good morning, John McAuliffe, Delegate from the 30th District, all of Western Loudoun County and Northern Fauquier. Great to be here.
Good morning, J.J. Singh, 26th District, Loudoun County, and I'd like to thank the chair for his leadership.
Good morning, Delegate Benita Anthony, the 92nd House District, who covers portions of Norfolk and Chesapeake.
Good morning, Delegate Stacey Carroll, represent parts of Stafford, the 64th District.
Israel O'Quinn, I represent the 44th District, which is City of Bristol, all of Washington County, and half of Russell County.
Jay Leftwich, represent the 90th House District, which is the southern part of Chesapeake.
And we would not be remiss if we did not recognize and honor our wonderful staff who are working with us today, too. Ms. Knight?
My name is Joyce Knight. I'm the Committee Operations Clerk.
And I'm Terry Lynn. I'm just helping out. I'm Brooks Run.
Thank you so much. Getting right down to business this morning, we have two pieces of legislation that were drafted as constitutional amendments, which technically will be before us properly next year. So we're going to move HJ 14 and HJ 45. If I can have a motion to carry over to 2027.
Second.
Properly moved and seconded that we move HJ 14 and HJ 45 over to 2027. Is that a voice vote or a recorded vote? A voice vote. All those in favor say aye.
Aye.
The motion is agreed to. Joining us to my immediate right. Introduce yourself.
Is this our first meeting? Seems like we've already been here a year. I'm Delegate Krizak. I represent the 16th District of Fairfax County, Southeast Fairfax County. Thank you.
Awesome. Thank you so much. We're ready to get started, and the first bill before us this morning is HB 59. Delegate Ware.
Thank you, Mr. Chairman. Good to be with you this morning. I have, as you say, House Bill 59, and it's a bill that follows on what I anticipate will be the successful passage of the Second Chance Constitutional Amendment for folks who will get their voting rights restored. I anticipate, as I think most of us do, that will pass. That being the case, in one of the counties that I represent, there is an institution, the Virginia Center for Behavioral Rehabilitation, and this institution has over 400 inmates. I think the current number is, I've got it here, 411 residents who will, because they're civilly committed at this point, would be eligible to receive their voting privileges under the provisions of this new constitutional amendment. If they were to do so, they would become the largest precinct in a small town in which they reside under the auspices of the Commonwealth. The town of Crewe, for example, had 590 votes total cast for mayor, and it is in the most recent election for which they had it. Council winners most recently have won by 323 votes, 95 votes, 159 votes, and so forth in the elections that there have been. So overnight, this institution would become easily the largest precinct in this small town and could, even though they're not actively involved in the affairs of the town, become the dominant political force in the town. So what this bill would provide is that those who are at VCBR would have their voting rights established where they most recently lived. That's a very simple statement of it. I'd be glad to answer other questions, but that's where it comes from. The town has requested this legislation, anticipating, as I think most of us do, that this amendment will pass and that will create quite a number of new voters in that circumstance.
Thank you, Delegate Ware. Turning to the subcommittee, Chair Price.
Yes, thank you, Mr. Chair. I just want to make sure I got lost somewhere. And from my understanding, when you're away from home, you can vote by absentee ballot, but your home is your home.
Right.
Right. I thought this was dealing with when you're counted for like the census, for drawing districts, and for reapportionment purposes, that just like we ended what people call prison gerrymandering, that you would be counted at your home, this would now be that for civilly committed folks. But I just want to make sure that, because I'm not sure, it's early, I'm trying to get there. Can you point to where in the bill you are basing your conversation about voting?
Mr. Chairman and Madam Chairman, I think you have actually hit on the gist of the legislation. I probably, in describing it, have slightly moved a different direction, but I think you're exactly correct in terms of the allocation and redistricting.
Any other questions from the committee? Delegate Carroll.
Thank you so much, Chair for the patron. Question for the patron.
Delegate Carroll.
Yes. Mr. Chair, the question for the patron goes into, in general, I know he specifically provided information on the, as it relates to a small town within his specific district, but wasn't sure, and utilizing the example that you provided for the behavioral health institution, is there currently a process in place that would ensure that the personnel that are there at this particular facility, if they would be able to provide the necessary assistance to assist in the absentee ballot and voting rights process of there?
In terms of what would be available, I would take it that the authorities in the prison would be able and willing to pass along the ballots for absentee voting in the localities from which they come. If that's if I've hit on the question that you're actually asking.
Partially. I guess my concern would be is, to me, and in my understanding, and should I not have interpreted right because it's 7 o'clock, I apologize. But to me, it would be ensuring that this new concentration of voters that have that are civilly committed to perform the necessary rehabilitation that's needed for them to return to society doesn't then come in and more or less kind of skew the population of this specific town and their voters and kind of turn the position is what I hear the natural concern is. So we would want to ensure that the voters aren't given the opportunity to change their voting registration location to the place that they're civilly committed at.
That's correct.
To be at their home of record, but at the specific facility. Yes. I just want to make sure I understand.
You explained it right on the money.
Okay.
I'm going to take chair's privilege real quick and ask if council would explain the bill. It's early in the morning. Mm-hmm. I want to charge it to our heads and not our hearts this morning. So if you could just succinctly explain the bill to make sure that we're all on the same page.
Yes, Mr. Chair. The bill as it's drafted deals only with redistricting. So what it does is it takes that population that is in these civil commitment facilities and redistributes that population back to where they were prior to their commitment for the purposes of redistricting only. It does not affect their voting. How they vote, if they are given the ability to vote later on because of the constitutional amendment or what have you, depends on their domicile and their residence. So if they maintained a residence back where they were, they can vote there. If they say their new residence is that facility, they can vote at the facility, but that has to do with where their residence is and domicile. That's not this bill.
Thank you. Any further questions from the committee?
Mr. Chairman.
Delegate Anthony and then Delegate Krizak.
Thank you, Mr. Chair. Mr. Chair, I would like to ask the patron about any possible administrative burden, particularly with collecting of demographic and address data. If you could possibly explain that administrative workload and what would be that fiscal impact.
Candidly, Mr. Chairman and Delegate, I think probably members of this committee could explain that better than I could in terms of the process of the election and the voting work. So I'm going to defer either to your counsel or to other members of this committee, because you are intimately familiar in a way that I am not with how that would transpire.
Thank you, Mr. Chair. Follow up.
Do you want
to answer?
Did I want to?
Do you want staff to answer?
Yes, please.
Counsel, I'm sorry.
So, Mr. Chair, Madam Delegate, if I understand the question correctly, you're asking about the data about these inmates that the behavioral health facilities have?
Yes, yes.
And how they would, so I imagine it would come through the court process similar to how it comes to the Department of Prisons. So, but instead of going to a prison, they're just being diverted to these behavioral health facilities because they've been found to be, they're being civilly committed, not imprisoned, if that makes sense.
Thank you, Mr. Chair, Counsel.
Delegate Anthony.
Krizak.
Oh, you finished? Okay. Delegate Krizak.
Thank you, Mr. Chairman. I like where you're going with this bill, Delegate, but I have a little concern. So explain to me a couple things. One is, when we have the redistricting, we're going to have to, there's going to be some changes to our maps for our delegate senator maps, because this is going to change populations, and there's going to be some unintended consequences there, maybe. But I want to know if states that have tried similar adjustments have seen litigation over this method in redistricting, and does it conflict? I know it excludes the use of this data for federal state aid distribution and other things, so it's only about redistricting. But does it conflict with the federal definitions or census practices? Thank you.
Again, I'll have to defer to the council on this, Mr. Chairman, Delegate Krizak, because that is an area of the electoral law that I'm just not familiar with.
Council.
Chair, Delegate Krizak. So prison gerrymandering and efforts to alleviate that through reallocation of prison populations has been done in other states. It's widely accepted practice at this point. As far as I know, this is a novel approach. One difference might be that in the case of prisons, that population, for the most part, aren't voting because they're being held in prison under a felony. And even under the constitutional amendment, they wouldn't get those rights back. In this case, it's something a little bit different, that this population could vote in this place. So whether to redistribute them is maybe a little bit different. So there might be some nuances there. But otherwise, it's, again, analogous to that prison redistribution process that we already have, and that, is accepted.
Chair Price.
Yes, thank you. I just wanted to remind the subcommittee that I passed the bill that established the original language, and we are adding civilly committed people. So it would be ending gerrymandering, which we like, for the people that are civilly committed. Just wanted to put that out.
Delegate Leftwich.
Thank you, Mr. Chair, and I appreciate the Uber Chair's comment, because I had a question as to whether, for my own clarification, as to whether or not we already treat prison inmates in the same fashion. I don't see any point in being inconsistent. and I would tend to support the bill.
Any further questions from the subcommittee? All right, turning to the audience, if anyone is in attendance today in favor of the bill, anyone in opposition to the bill? Is there anyone online? Turning back to the committee, what is your pleasure?
Mr. Chair,
Delegate
a
O'Quinn.
question, actually. And I understand this is not the Public Safety Committee, but I don't know, during the drafting of the bill or during the research of the bill, I'm just curious, how many individuals are actually civilly committed in Virginia in a facility?
In this facility, the latest census was 411.
Do you know the number state? Sorry.
That I do not have.
I was just curious.
The committee operates on motion.
Second.
Hearing properly moved in second, the bill, hearing that the bill is properly moved and seconded, the clerk shall open the roll. Clerk shall close the roll. The bill is reported 8-0. Thank you, Delegate Ware.
Chairman, thank you for the generous help that a number of you have given to me on this, so appreciate it.
Delegate Helmer.
You ready for the Senate?
Thank you, Mr. Chair, members of the subcommittee. Good morning. House Bill 113 simply says that we should look at what happened in Wisconsin with Elon Musk offering $1 million as a lottery prize for people to register to vote, and suggests that that is not something we would like to see replicated in Virginia. It also clarifies existing law to ensure that de minimis support for folks who are going to vote doesn't accidentally get caught up otherwise in our existing laws. So if you had a food truck or water or something like that for people who came up to vote, making sure that we are very, very clear what we've already interpreted to be the case, that de minimis support, for folks who show up to vote in any election isn't what's intended by this bill. I hope it is the will of the subcommittee to report the bill. And I think there might be a friendly amendment held by one of the subcommittee members.
Delegate Singh.
Mr. Chairman, in my view of this bill, it seems clear to me that you don't intend paid registration drives, and I don't think the language does, but this would make sure that it's clear. So I have an amendment that would add a fourth bullet under subsection B. So that would be on line 18, strike or, and on line 19 after a vote, strike the period and insert or. And then after that, you'd say paying a person a wage to conduct a voter registration drive.
I would regard that as a friendly amendment, Mr. Chair.
All right. Just make sure that council is ready. Okay.
Second.
It's been properly moved and seconded. All those in favor say aye. Aye. The amendment is agreed to. All right, now back before us again. Any questions from the committee? Seeing none, turning to the audience, is there anyone here in favor of the bill? We'll set the time for 2 minutes.
Good morning, Mr. Chair, members of the subcommittee. Blair St. Ledger Olson with the Virginia League of Conservation Voters. This is my first time testifying before this subcommittee, and I promise I will quickly scurry back to ag where you all expect me to be. But Virginia LCV does run $1 million nonpartisan voter registration programs every year. We run nonpartisan civic engagement and mobilization programs every year across the state because we believe fundamentally that voters' belief in the fairness and ethical realities of their election system is critical to all of the work that we do here. So we thank the patron for this important movement to try to reinstate that security and comfort within our voter base, and we would ask you to move the bill forward. Thank you.
Thank you. Is there anyone here in opposition? Is there anyone here online? All right, returning back to the subcommittee, what is your pleasure?
Move to report.
Second.
It's been properly moved and seconded that we report HB 113. The clerk may open the rolls. The clerk may close the roll. The bill was reported 8-0. Thank you, Delegate Helmer. All right, turning to HB 213, Delegate Feggins.
Good morning, Mr. Chair and members of the committee. HB 213 works to ensure that uniform overseas voters and their families are treated the same for ballots. Under current code, uniformed service members can be limited to only federal-only ballots. This bill removes that distinction and allows otherwise qualified overseas voters, which mainly are uniformed service members and their families, to receive the same ballot for state and local election. This bill does not expand voter eligibility or change registration standards for our uniformed voters and their families. It simply eliminates unnecessary barrier and the need for a separate federal-only ballot. I respectfully ask for the subcommittee to report and vote favorably.
Thank you, Delegate Feggins. Turning to the subcommittee. Anyone have any questions? Seeing none, we'll go to the audience. Is there anyone here in favor of the bill? Is there anyone in opposition to the bill? Is there anyone online? Turning back to the subcommittee, what is your pleasure?
Second.
Mr. Chairman, is there a first? Does it need to go to first?
I don't have a letter on this. Well, hearing that it's been properly moved and seconded, the clerk may open the roll. The clerk may close the roll. All right, that bill reports 7-1. Thank you, Delegate Feggins.
Thank you, Mr. Chair and members of the committee.
I forgot to do this in the beginning of the committee, but we do have Delegate Hope's 493, which the patron has asked for the bill to go by for the day, and I'll entertain a motion.
Second.
It's been properly moved and seconded that we pass by for the day Delegate Hope's HB 493. All those in favor say aye. Aye. It's been properly moved and seconded that it has been moved that we pass by HB 493 for the day. All right, we have 3 more bills before us. Seeing that I do not see Delegate Tran here, I'll call on Delegate Krizak to present your HB 640.
Thank you, Mr. Chairman.
And before you get started, Mick, looks like you may need to make a motion.
Yeah. Is there a substitute? Yeah, there's some technical line amendments from the Supreme Court.
All right, I'll entertain a motion for the substitute.
So moved.
Second. Been properly moved and seconded that we embrace the substitute. All those in favor say aye. Aye. All right, the substitute is now before us.
That just, the line amendments are just aligned as part of the code with their current operational practices. What this does, in a nutshell, is it removes the authority for voter-initiated election day challenges at the polling place. Doesn't affect registrar authority, doesn't affect list maintenance or eligibility verification or criminal penalties for illegal voting. But why it's necessary is that really polling places are not designed to adjudicate eligibility disputes. Poll workers lack the access to records necessary to resolve that residency, registration status, or duplicative registration claims in real time. And as a result, same-day challenges rarely improve accuracy and often defer resolution anyway. The risks really outweigh the benefits. That's the issue here. You get disruption at the polling place, voter confusion, intimidation claims, inconsistent application across localities. So this is just removing a low-use, high-risk process, which improves uniformity statewide. It leaves intact, as I said, registrar-led list maintenance and verification, pre-election eligibility challenges, post-election investigations, prosecutions, existing penalties for legal voting. It just simply moves it out of the polling place. That's the bill in a nutshell.
Thank you, Delegate Krizak. All right, turning to the subcommittee, are there any questions? Seeing none, we'll go to the audience. Is there anyone here today in favor of the bill? And we'll set the time at 2 minutes.
Good morning, Mr. Chair, members of the subcommittee. Tram Nguyen with New Virginia Majority. Thank you, Delegate Krizak, for introducing this legislation. This has come up a couple of years ago too, and was passed. I think Delegate Sickles had the legislation, and so we're glad to have it brought forward. It's just trying to make sure that when we have voter challenges and challenges to voters, that it could be there's time to properly vet these challenges, and we'd want to take it outside of the polling place on Election Day because, as Delegate Kriesek mentioned, it can be disruptive. And then also making sure that general registrars can focus and election officers can focus on their duties to administer the elections and not have to worry about these sometimes frivolous challenges. So thank you.
To the bill. And I believe we have one person online. Okay. No longer there. Turning back to the subcommittee, Delegate O'Quinn.
Thank you, Mr. Chair. I have a question for the patron. Thank you, Mr. Chair. I would ask the patron, so I haven't actually witnessed one of these Election Day challenges. So could you walk us through who can challenge in this situation and how that process plays itself out in the polling place, the situation you're trying to prevent?
Mr. Chairman, what you would not have an Election Day challenge at the polling place. So that's all the other challenge enforcement mechanisms remain, but not on Election Day. So that situation that you witnessed would be out of order, and they would say, sorry, you can't challenge on Election Day. It's the worst place for resolving eligibility questions. Like I say, there's no meaningful due process. That's number one. And they just have limited information. And it's a high-pressure situation. As you heard from the testimony, we need the poll workers and everybody there, the registrars, to be working on, like, make sure everything's accurate and voted. Everybody gets to vote, and not having to deal with a disgruntled person screaming and yelling, maybe about somebody's maybe or should be not here. But there's plenty of processes to make it happen ahead of time or after the fact.
Follow up, Mr. Chair. Mr. Chair, I apologize to the patron. So I have not, let me be clear, I've not witnessed one of these situations. So my question was more of under current law, not under the law as your bill imagines it, but under current law, then who has the right to object under current law, and how does that process play itself out in a polling location?
Mr. Chairman, to answer the delegate, my understanding is right now any one person can challenge any other person under current law on Election Day at the polling place.
We were able to get Ms. Van Breda online, and so we'll turn back to her for her comment and support.
Great. Thank you, Mr. Chair, members of the committee. My name is Irina Van Breda. I live in Fairfax County in Delegate Kriesek's district, and I am here to speak on behalf of the League of Women Voters of Virginia. We absolutely support this bill, and we thank Delegate Kriesek for bringing it. The challenges that the bill would revise are antiquated and infeasible to implement. The bill properly moves the challenges into the court system where it belongs. So we strongly support the bill. Thank you.
Thank you. Delegate Leftwich.
Thank you, Mr. Chair. So I understand the purpose of trying to take this outside of the voting arena. But how if this takes place prior to Election Day, in other words, you apply for a printed ballot to submit, how would any red flag be raised to challenge it after the fact?
Mr. Chairman, this does not eliminate challenges. This just eliminates challenges at the polling place on Election Day. All the other challenges in the code are still there. It also still does not impact the Virginia Department of Elections list maintenance process, which cancels voter registrations based on deaths, change of address, felony status, non-citizens identified through administrative matches, etc. So this is just what this does is it prevents Virginia voters on Election Day from being challenged at the polling place.
Follow up. Thank you, Mr. Chair. I have to associate my comments with Delegate O'Quinn in that I have not witnessed or experienced this. But so if you're and I don't like controversies anywhere, much less a polling or ballot place. But so if you go to the poll and you try to vote and you've got somebody who challenges that person's ability, whether it's someone who's standing there saying state your address or it's another person within the ballot arena, there's a contemporaneous awareness of someone trying to vote who may not be eligible to vote. In this situation, they apply. One person's by law, you're required to provide them with the ballot. If they certify what's in the statute, they cast their ballot. And then how would anyone ever be aware unless you went in and did
I think you're, Mr. Chairman, I think you're hitting exactly why we need this law. The problem is it's inconsistently applied across localities. Every single registrar handles it differently because it's so rare. And what we're concerned about is it could become more frequent and more chaotic. But it's a rare occurrence that happens it doesn't happen often enough that there is actual consistency. So one registrar might treat that situation in a different way. It's just disruption at the polling place operations. It's not the venue for voter challenges.
All right. Coming back to the subcommittee, what is your pleasure?
Mr. Chairman, have we already moved the substitute?
Yes, we have.
Okay.
Move to report as substituted.
Move to report as substitute. Second. Been properly moved and seconded. The clerk shall open the roll. The clerk may close the roll. The bill is reported 6-2. Thank you.
Thank you, Mr. Chairman.
Turning to Delegate Anthony.
Thank you, Mr. Chair, members of the committee. I have before you HB 1244, titled Elections Absentee Voting, Emergency Application for Absentee Ballot. Before we get started, I do have two narrow line item amendments in the form of a substitute that I would like to briefly speak about those amendments. So first, if you're looking at the language here, all these amendments are occurring in subsection A, starting on line 22. The first amendment is a timing trigger clarification. So in subsection III, the bill currently refers to a voter who has not received a ballot within 4 days of the election. My amendment replaces the word "for" with 10 days. This aligns with the statute with practical mail delivery timelines and with the existing absentee ballot request deadlines. It does not change who is eligible to vote. It simply provides a realistic and administrable standard for registrars. And so the second amendment clarifies timely compliance also on line 22. It says in the same clause, I want to add the words "by the deadline" after the phrase "has applied to receive an absentee ballot." I want to make clear that the voter complied with the law and requested their ballot on a timely, but it never arrived. The ballot never arrived. So I wanted to make those two clarifying line amendments. I believe it'll be in the form of a substitute.
I move the substitute.
It's been properly moved and seconded, and the substitute is properly before us.
Thank you so much. Here for HB 1244, like I said before, the two amendments narrow the clarification. We wanted to make sure that the voter timely requested an absentee ballot. The ballot never arrived. Then the voter suffered a serious medical emergency that prevents in-person voting. So what this bill does, here it governs the emergency absentee ballot where it is close to close a narrow but consequential gap in the state election law. And so under current law, a voter may request an emergency absentee ballot only if a qualifying emergency prevented them from applying by the deadline, or a qualifying emergency arose after the deadline that prevents voting in person on Election Day. So in both cases, the statute assumes the voter either never had the opportunity to apply or became incapacitated only after the deadline passed. This bill ensures that voters who did everything right, but whose ballots never arrived, and who then experienced a qualifying emergency. We want to make sure that these voters are not disenfranchised by circumstances beyond their control. I just wanted to reiterate that this bill does not expand absentee voting eligibility. It does not weaken any verification or fraud safeguards, and it does not require any state funding or imposed administrative costs. All existing witnessing requirements, representative rules, and felony penalties remain unchanged. So simply, HB 1244 ensures that no Virginian has to choose between medical care and the right to vote. Mr. Chair, I hope it be the will of the committee to report this bill.
Thank you, Delegate Anthony. And I'm sorry, I made a little fib. The substitute is not properly before us. It's been properly moved and seconded that we move the substitute. All those in favor say aye.
Aye.
Now the substitute is properly before us. Turning to the committee, Delegate Lefwich.
Thank you, Mr. Chair, and I just want to make a comment that you have me at United States Postal Service.
Is there any other further questions for the subcommittee? All right, turning to the audience, I believe we have quite a few people here in support of the bill and a few people online as well. We'll set the clock at 5 minutes. Let's keep this in mind. This is 5 minutes for everyone in total, not 5 minutes for you alone.
Good morning, Mr. Chair, members of the subcommittee. Tram Nguyen with New Virginia Majority. We thank Delegate Anthony for carrying this legislation. So currently, if you apply for an absentee ballot and you don't get it or it's messed up or something, during the early voting period, you can show up and you fill out and you sign this affidavit on what we call the goldenrod form, right? And then you can receive an absentee ballot. So for folks who are in an emergency situation, as Delegate Anthony mentioned, and they don't receive their absentee ballot that they requested in the mail, but then they're incapacitated, they're hospitalized, they don't have that ability to then go in and do that process that exists for people who are physically able to go in during the early voting period. So this provides an opportunity for them to take advantage of the existing emergency absentee provisions that are in place that allows them to have a representative come and just work through that process. So it doesn't change the law, it just provides another option for folks who just, due to unforeseen circumstances are not able to cast an absentee ballot.
Good morning. My name is Gina Koch. I'm a close personal friend of the late Karen Tefelsky. She was a lobbyist here at General Assembly, and she was the executive director of Virginia Access, which is a organization that protects the rights of people with disabilities. She was diagnosed with pancreatic cancer back in 2023, and I assisted her with her medical care. As time went on, she was at the hospital, and the oncologist let her know that her time was just days away. At that point, she had already requested an absentee ballot, but the ballot had not come in the mail yet. I kept checking the mail, it didn't come. The oncologist then made transportation arrangements for her to go to the hospice house in Bon Air, and so that included a medical transport. She absolutely refused the medical transport and insisted that one of our friends take her to Ashland to her voting precinct where she did curbside voting. This process was very important to her. Her life was all about being able to vote and being able to have a say in the process. And because she was able to show up at the last minute, it was the 29th, she was able to vote, but had she gone straight to the hospice house, she would not have had the opportunity to vote. And so this opens the door for people who have extenuating circumstances to be able to provide their vote. And I really strongly encourage you all to vote in favor.
Hi, I'm Tanya Milling, Executive Director of the ARC of Virginia and close friend of Karen Tefelsky. And we just really, as Gina said, watching her exercise that right so passionately and dedicating her life to people with disabilities, we want to make sure that people who are in similar circumstances have the same opportunity. So please support this bill. Thank you.
Is there anyone here in opposition to the bill? Seeing none, we'll turn online to those here. We have Ms. Van Breda again.
Yes, thank you, Mr. Chairman and members. The League of Women Voters of Virginia supports this bill. We hope that everyone will. As already described, there's no reason why anyone should lose their opportunity to vote simply because they were unable to get their absentee ballot delivered in a timely manner. So thank you very much.
Thank you. Ms. Aceto.
Hi, hello, members of the subcommittee. Thank you so much for Delegate Anthony for presenting this bill. I am also in favor of it. As Gina Koch so eloquently stated, Karen Tefelsky was passionate about voting. She would vote in person. She would take her neighbors to vote. And in those last couple of weeks, when this was not an option for her, we appreciated the efforts of some of your colleagues to try to assist us so that she could get to vote. As Gina said, she wanted to get that vote in. As a citizen of Virginia, as someone who has worked on legislation for her entire career, this meant so much to her, and she got it done. And it was important to her. She also knew in those last couple of weeks that this was something we wanted to work on for her behalf. I also submitted written testimony, which I believe you all have, and I would appreciate your support for this bill. Thank you.
Thank you. Turning back to the committee, Delegate O'Quinn.
Thank you, Mr. Chair. I have a question for the patron. Thank you, Mr. Chair. So in adding this new category, so to speak, to the emergency application section, have you received any feedback from either local registrars, the Registrars Association, or elected to any additional logistical issues that they may face in those last 4 hectic days prior to the election?
Mr. Chair, I will answer the delegate. We have not received feedback, but we wanted to make sure that we align our amendments to current election law and current election deadlines, hence why I did the 2 line item amendments so that it will align perfectly with whatever is happening in practice. This just adds another trigger. I believe that Karen and her vigor and wanting to make sure that her voice was heard, she transitioned a few days later after she casted that ballot. So we appreciate her being able to lift up her voice. Thank you, Mr. Chair.
All right. Seeing no further questions from the committee, what is your pleasure?
Move to report with amendments.
Second.
It's been properly moved and seconded. The clerk shall open the roll. The clerk shall close the roll, and that bill is reported 8-0. Thank you. All right, the subcommittee will stand at ease momentarily. 14.
She's much nicer than me. Good morning, Mr. Chair and members. On behalf of Chair Kathy Tran, I have House Bill 1014, and this bill is about ensuring that one of our most fundamental rights, the right to vote, is not taken away automatically, but only when it is truly warranted. And under current Virginia law, when an individual is placed under a guardianship or conservatorship, they lose their right to vote by default, regardless of their actual ability to understand or participate in the voting process. Under this bill, instead of automatic disenfranchisement, courts are required to make a specific finding supported by clear and convincing evidence that an individual lacks the capacity to understand the act of voting before their voting rights may be removed. If the court does not make that finding, the individual retains their right to vote. In periodic review hearings, the court must assess whether the individual's capacity to vote has changed. Virginia would not be alone in taking this approach. 22 states already operate in a similar manner to ensure that individuals who are in a guardianship or conservatorship are not automatically stripped of their right to vote. She respectfully asks for your support of House Bill 1014, and she is happy to answer any questions.
Thank you, Madam Chair. Any questions from the subcommittee? Seeing none, we will go. Delegate.
That's okay.
All right, we will turn to the audience. Those in favor, we'll set the clock at 2 minutes.
Morning, Mr. Chair. I won't take the whole 2 minutes. Jared Calfee with AARP Virginia. We support the bill. I would also highlight that a bill identical to this one was passed last year. We think it's critically important that people's voting rights are never taken away by default, and that there is a fair hearing, and that that decision is made not by default, because voting rights are critically important to protect, and that's why we support the bill and hope you'll pass it. Thank you.
Thank you. The patron is now here, so she can assume the place. Are there anyone here in opposition to the bill? Seeing none, we will turn to online support. There are quite a few people, so we will set the clock at 5 minutes. Please keep in mind, these 5 minutes are for all of you all as a whole, not for it as an individual. We will turn first to Ms. Jen Krajewski.
Good morning, Mr. Chair. Jen Krajewski with the Virginia Board for People with Disabilities, and I would echo the comments of the previous speaker, and we support this bill. Thank you.
Thank you. Ms. Rebecca Herbig.
Good morning, Mr. Chair and Subcommittee. My name is Rebecca Herbig. I work with the Disability Law Center of Virginia, and we are strongly in support of this bill.
Thank you. Ms. Van Breda.
Yes, hi, Irina Van Breda for the League of Women Voters of Virginia. We support this bill. We have had personal experience. One of our members was approached by a mother whose daughter had Down syndrome, and she sought conservatorship just for financial matters for her daughter. During that hearing, no one explained to the mother or the voter who had voted in the past that she would lose her right to vote. And it wasn't until after the hearing and when she went to go and vote the next time, she was told that she'd lost her right to vote because her mother had been just trying to protect her from people taking advantage of her kind heart. That shouldn't happen to anyone. It should not be a default decision to lose your right to vote simply because you may be under guardianship or conservatorship for other matters. So thank you very much, and we strongly urge the committee to support this bill.
Thank you. Ms. Lucy Beadnall.
Lucy Beadnell from the ARC of Northern Virginia. We wanted to thank Delegate Tran for carrying this bill again and give it our strongest possible support. It's one of our top priority bills for this year, and echoing the words of Ms. Van Breda, we have had multiple people come to us receiving a surprise guardianship order, finding out then for the first time that their right to vote had already been removed. Thank you.
Thank you. Chris Kaiser.
Thank you, Mr. Chair and members. I won't add too much that hasn't already been said, but we all have a fundamental due process right that you can't lose the right to vote without first an individualized consideration about that and a right to be heard. So the main thing this bill does from a constitutional rights standpoint is to resolve this ambiguity in the current code related to guardianship appointments, where it's not totally clear that before a person's disqualified from voting based on incapacity, a court has to make that individualized finding related to the ability to understand the act of voting, in addition to any other findings associated with the appointment of a guardian or conservator. So in other words, the mere fact of an appointment can't constitute incapacity for voting purposes. So important safeguard for people with disabilities in particular, and we thank Delegate Tran for bringing the bill.
Thank you. Turning back to the subcommittee, Delegate O'Quinn.
Thank you, Mr. Chair. I have, I think, 2 questions for the patron. Thank you, Mr. Chair. I would ask the patron, so now there is an evidentiary proceeding for general incapacity. Would this add a second evidentiary hearing for capacity to vote, separate of that?
Mr. Chair, if we can please bring Chris up from the ACLU, I think he can explain the legal process.
Chris online.
Happy to, Delegate. If I understand the question, Delegate, would there be a separate hearing? The answer is no. I think that you have the same consideration that you do today. That you just have to make sure there are individualized findings on the specific question about whether the person has the capacity to understand the act of voting. So that could be done in the same hearing. We just want to make sure that the analysis is being done on that discrete issue.
Mr. Chair, then I'm not sure who I'm directing this. What would be my second question? Now I think I have 3. I understand that, but if someone's been found generally incapacitated, then wouldn't this create a second hearing ultimately? If that first finding has occurred, and then now someone wants to go this next step, would that not create a second hearing as opposed to coming forward all at once with these same 2 issues?
I'll look to counsel.
Mr. Chair, that's outside of my purview. That's a court's question, but yeah, if someone else has.
Mr. Chair, what we could do is just, on that very technical question, is make sure we have an answer for Delegate O'Quinn if this moves forward to full committee and be able to address it.
Okay, thank you, Mr. Chair. And my final question would be, am I reading this correctly then that, and this ties into my first 2 questions as to these hearings coming at once, or there have been a prior hearing on the first question and a new hearing on the second? Am I reading the bill right that this is technically retroactive, so any of those prior findings could come up for a second hearing, and then any going forward, you could deal with these same 2 issues all at once?
Counsel, could you clarify that? Because we do have, how that works with the enactment clause.
Mr. Chair, Delegate, could you repeat that again?
I'm trying to make sure I understand that, and I'm reading the bill correctly, that it is retroactive. So if this bill were to pass, signed into law July 1, 2026, this would be retroactive for cases prior to July 1, 2026. Thus, going forward, after July 1, 2026, in an evidentiary hearing, you could address general incapacity as well as voting capacity in one hearing. For anyone who's been deemed incapacitated prior to July 1, 2026, then that would allow a venue for what would then be their second hearing to determine exclusively their capacity to vote.
I believe, Counsel, that it's addressed in lines 275 to 280, and that you are able to, because, Mr. Chair, if I may, because what has been happening is that if you're found to be placed under guardianship or conservatorship, then your right to vote has been automatically taken. This gives a chance for those individuals whose rights have been automatically taken to have an opportunity to say, hey, I'm actually under these 2 circumstances for other reasons, but I do have the capacity to vote. So it gives them that chance. That's how I interpret those lines. 275 to 280.
Delegate Price. Chair Price, I'm sorry.
Yeah, Mr. Chair, I would say that it's quite like, if you pass a bill that allows for a new court order to do community service, you can go back for a new hearing for a judge to be able to grant that once that becomes legal. And so there are different reasons why people get new hearings. And so this wouldn't be out of the ordinary for, just like, I'm not in any way equating this to criminal, but it would, be like that. So hopefully, the example that we heard where the daughter was fully able to understand voting, but just maybe needed a little extra protection when it came to finances, would be able to then go in and say, okay, she can get her rights back.
Delegate Krizak.
Mr. Chairman, I just wanted to respond to the delegate's first question regarding the hearing issue. If you look at line 263 or 262, 261, it starts on with no court shall find a person disqualified to vote due to lack of capacity pursuant to this section based on a determination of a guardian ad litem in the report submitted in accordance with section 64.2-2003 without a showing that reasonable accommodation appropriate to such person's diagnosis or condition has been provided for the purpose of determining such person's capacity to understand the act of voting. So it sounds to me like it happens right at that same time. What this is just saying is that it's not an automatic disqualification. You just, because you've been adjudicated and mentally incapacitated, you don't ipso facto lose your right to vote as well. But the next part of that hearing would be to going through and making sure that then they would do the adjudication for the voting rights based on the normal factors. Does that make sense?
All right, turning back to the committee, what is your pleasure? It's been properly moved and seconded that we report HB 1014. The clerk may open the roll. The clerk shall close the roll. The bill reports 6-2. Thank you.
Thank you, Mr. Chair.
Seeing that I believe the business of our subcommittee is finished for today, I will entertain a motion to adjourn.
Second.
It's been properly moved and seconded that we adjourn. The committee shall rise. Oh, all those in favor, I'm sorry. Aye. Now the committee shall rise.
You got to vote.